Cornell Law School. U.C.C. Article 2A, Leases, Part 1. General Provisions. Paragraph 2A-104. Leases subject to other law. 1. A lease, although subject to this article, is also subject to any applicable A. Certificate of title statute of this state. List any certificate of title statutes covering automobiles, trailers, mobile homes, boats, farm tractors, and the like. B. Certificate of title statute of another jurisdiction, section 2A-105, or C. Consumer protection statute of this state, or final consumer protection decision of the court of this state existing on the effective date of this article. 2. In case of conflict between this article, other than sections 2A-105, 2A-304, 3, and 2A-305, 3, and a statute or decision referred to in subsection 1, the statute or decision controls. 3. Failure to comply with an applicable law has only the effect specified therein. Paragraph 2A-105. Territorial application of article to goods covered by certificate of title. Subject to the provisions of sections 2A-304, 3, and 2A-305, 3, with respect to goods covered by a certificate of title issued under a statute of this state or of another jurisdiction, compliance and the effect of compliance or non-compliance with a certificate of title statute are governed by the law, including the conflict of laws rules of the jurisdiction issuing the certificate until the earlier of A. Surrender of the certificate, or B. 4 months after the goods are removed from that jurisdiction, and thereafter until a new certificate of title is issued by another jurisdiction. Paragraph 2A-106. Limitation on power of parties to consumer lease to choose applicable law and judicial forum. 1. If the law chosen by the parties to a consumer lease is that of a jurisdiction other than a jurisdiction in which the leasee resides at the time the lease agreement becomes enforceable, or within 30 days thereafter, or in which the goods are to be used, the choice is not enforceable. 2. If the judicial forum chosen by the parties to a consumer lease is a forum that would not otherwise have jurisdiction over the leasee, the choice is not enforceable. Paragraph 2A-107. Waiver or renunciation of claim or right after default. Any claim or right arising out of an alleged default or breach of warranty may be discharged in whole or in part without consideration by a written waiver or renunciation signed and delivered by the aggrieved party. Paragraph 2A-108. Unconscionability. 1. If the court as a matter of law finds the lease contractor any clause of a lease contract to have been unconscionable at the time it was made, the court may refuse to enforce the lease contract, or it may enforce the remainder of the lease contract without the unconscionable clause, or it may so limit the application of any unconscionable clause as to avoid any unconscionable result. 2. With respect to a consumer lease, if the court as a matter of law finds that a lease contractor any clause of a lease contract has been induced by unconscionable conduct, or that unconscionable conduct has occurred in the collection of a claim arising from a lease contract, the court may grant appropriate relief. 3. Before making a finding of unconscionability under subsection 1 or 2, the court, on its own motion or that of a party, shall afford the parties a reasonable opportunity to present evidence as to the setting, purpose, and effect of the lease contractor clause thereof, or of the conduct. 4. In an action in which the leasee claims unconscionability with respect to a consumer lease, A. If the court finds unconscionability under subsection 1 or 2, the court shall award reasonable attorney's fees to the leasee. B. If the court does not find unconscionability and the leasee claiming unconscionability has brought or maintained an action he or she knew to be groundless, the court shall award reasonable attorney's fees to the party against whom the claim is made. C. In determining attorney's fees, the amount of the recovery on behalf of the claimant under subsections 1 and 2 is not controlling. Paragraph 2A-109. Option to accelerate at will. 1. A term providing that one party or his or her successor in interest may accelerate payment or performance or require collateral or additional collateral at will, or when he or she deems himself or herself insecure, or in words of similar import must be construed to mean that he or she has power to do so only if he or she in good faith believes that the prospect of payment or performance is impaired. 2. With respect to a consumer lease, the burden of establishing good faith under subsection 1 is on the party who exercised the power, otherwise the burden of establishing lack of good faith is on the party against whom the power has been exercised.